Hello my dear students, in this lecture we are going to discuss the trespass to land, or you can also call it trespass to immovable property. After going through this module, we must be able to elaborate as to what constitutes the tort of trespass to land. We must be able to explain how it is committed, and we shall try to understand the trespass in airspace and above land, and we will also try to briefly analyze the nature and character of trespass, and finally to know what defenses are available to the tort of trespass. This term trespass means passing beyond, transgression or wrong. In legal terminology too, it was first used in the widest sense to include any wrongful act relating to a person or property. The expression trespass to land or immovable property literally means unauthorized interference with possession or enjoyment of land, that is immovable property of another. Trespass to land is an unjustifiable interference with the possession of land. An owner in the possession of land can bring an action of trespass against a person who interferes with his right of exclusive possession, whether by actually dispossessing him of the land or by intruding upon it or by doing an act affecting the sole possession of the owner, in each case without justification. In trespass, therefore, neither force nor unlawful intention nor actual damage nor the breaking of an enclosure is necessary. What is necessary is that there must be an invasion of property, that is private property, be it ever so minute, but without justification. To constitute the wrong of trespass, neither force nor unlawful intention nor actual damage nor the breaking of an enclosure is necessary. Every invasion of private property, be it ever so minute, is a trespass. Trespass may be committed by entering upon the land of the plaintiff or by remaining there or by doing an act affecting sole possession of the plaintiff, in each case without justification. For instance, entering another's land or house unauthorizedly or placing some physical object on another's land is a trespass. Trespass to land is an unwarrantable entry upon the land of another or any direct or immediate act of interference with the possession of land. According to Salmond, the possession of material object is the continuing exercise of a claim to the exclusive use of it. The possession is an outward symbol of ownership and it is protected by its own right. The law relating to offence of criminal trespass is laid down in section 441 to 462 of Indian Penal Code. Trespass into the property of another is a civil wrong when it is done with the intention to commit an offence on it, it will become a crime. Criminal trespass is defined under section 441 of Indian Penal Code. To constitute the offence of criminal trespass, there should be an unauthorized entry. If the entry is lawful, the offender shall remain there unlawfully with an intention to commit offence. Any unjustifiable intrusion by one person upon the land in the possession of another constitutes trespass. For every man's land is in the eyes of law enclosed and set apart from his neighbours, and that either by a visible and material fence, as one field is divided from another by a hedge, or by an ideal invisible boundary existing only in the contemplation of law. And when one man's land adjoins another's in the same field, a slight crossing of the boundary is sufficient. If the defendant places a part of his foot in the plaintiff's land unlawfully, it is in law as much a trespass as if he had walked a half-mile on it. It's also trespass to place anything on or in the land in the possession of another, as by driving a nail into his wall or placing rubbish against the wall. Same was held in the case of Gregory versus Piper, or a growing creeper up his wall as in Simpson versus Weber. One who has a right of entry upon another's land and acts in excess of his rights or after his right has expired is a trespasser. Trespass by a man's cattle is equivalent to trespass by himself. So also placing a ladder as a support on another's wall will be a trespass. In trespass, the injury should always be direct. If it is indirect and consequential, it may be a nuisance but not trespass. If I plant a tree on your land, that is a trespass. But if the roots and the branches of the tree on my land project on and over your land, it is a nuisance, as per Professor Winfield. If a man has allowed others to pass through a road on his private land, he obtains a right to sue them if they use the road in an unreasonable manner. Thus, in one of the celebrated cases, the defendant was the owner of a grouse moor crossed by a highway, the soil of which was vested in him, and the plaintiff on the occasion of a grouse drive went upon the highway for the purpose of interfering with the defendant in the enjoyment of his right of shooting. It was held that the plaintiff was a trespasser. Justice Loops said that the interest of public in a highway consists solely in the right of passage. As one of the judges observed that highways are no doubt dedicated prima facie for the purpose of passage. Our things are done upon them, everybody, which are recognized as being a reasonable and usual mode of using a highway as such. If a person on the highway does not transgress such reasonable and unusual mode of using it, I do not think that he will be a trespasser. The same was held in the case of Hickman versus Macy, where the defendant had walked to and fro on the highway for a distance of some 15 yards during about an hour and a half in order to watch the race horses trials on the plaintiff's land. He was held liable for trespass. A person who is the owner of a land on one side of a highway is presumed to have right over halfway of the public highway, that is, from the boundary of the land to the middle of the adjacent highway. He cannot sue a person for trespass who made unreasonable use of the other half of highway. Although a person may be considered as a trespasser as against the owner of soil of the highway, he will have a right of action against a negligent fellow passenger on the highway. In one of the celebrated cases, the driver of the defendant's lorry, which was loaded with a large box that made the lorry too high to pass beneath the bridge on the highway, tried to drive the lorry under the bridge, but the box collided with it and fell upon and injured a boy who was running behind the lorry. The boy was a trespasser on the lorry. Nevertheless, the defendants were held liable to the boy for negligence by the Court of Appeal. The court observed that even granting that the boy is a trespasser on the highway, he was entitled to get damages from the defendant for the negligence of the driver. Now, dear students, we will try to have an overview of trespass in airspace and above land. With regard to the right of a person over the airspace, above the soil. One of the maxims which forms the basic principles in this case is whose is the soil, his is also that is above it. This maxim does not mean any ownership over the infinite space, but means that if one owns a portion of earth or earth's surface, one also owns anything which is below that or that portion which is capable of being reduced into private ownership. Trespass over an airspace may be committed by an aircraft. In one of the cases titled Gifford versus Tent, where the tenant of the upper floor of a building affixed ornamental sign to his premises that it projected over a forecourt which was occupied by another tenant, it was held that a trespass was committed. In this case, the injury was direct and immediate, and the area invaded was that of ordinary user in possession of the plaintiff. An intrusion into the airspace of relatively low height constitutes trespass. It is now settled that the landowner's right in airspace extends only to such height as is necessary for ordinary use and enjoyment of the land and structures on it. With regard to trespass by aircraft, there are statutory enactments governing the law on the subject, both in England and in India. The Civil Aviation Act of England 1949, repealing the Air Navigation Act of 1920, Section 40 provides that no action shall lie in respect of nuisance by reason only of flight of an aircraft over any property at a height above the ground, which having regard to the wind, weather and all the circumstances of the case is responsible or the ordinary instance of such flights. But where material damage is caused by aircraft, damages shall be recoverable without proof of negligence from the owner of the aircraft. This amounts to a statutory recognition of existence of a right of property in overlying airspace with a restriction upon the remedies for infringement of that right. Trespass may be committed in many ways. Trespass by wrongful entry. The most common form of trespass is wrongful personal entry by defendant on the plaintiff's land. The slightest crossing of the boundary suffices, for example, putting a hand through a window or sitting on a fence. He who owns the surface of land also owns the underlying strata. Hence, any entry beneath the surface at whatever depth is an actionable trespass. For example, where the owner of an adjoining coal mine takes from under the plaintiff's land. Number 2 way of committing trespass is that trespass while remaining on the land of other person who has lawfully entered on the land in the possession of another commits a trespass when he remains there after his right of entry has ceased. Thus, a person who has entered by leave or license of the occupier will be liable as trespasser if after request he fails to leave the premises. Trespass by placing the things on the land. It's a trespass to cause any physical object to cross the boundary of the plaintiff's land or even to come into the physical contact with the plaintiff's land, even though there may be no crossing of the boundary. For instance, driving a nail into plaintiff's wall or throwing a stone upon his land or piling rubbish against the plaintiff's wall or pouring water would technically amount to trespass. There may be trespass by intervention of animals. Trespass by men's cattle, sheep, poultry is similar to trespass of land committed by the owner himself. Such a person will be liable and responsible for the trespass and consequential damages caused by his animal unless he can prove that the neighbor was under duty to fence the land and he had failed to do so. Now, dear students, we will try to understand the essential elements which constitute the tort of trespass. Number one essential is unauthorized interference. The plaintiff has to prove that there exists some unauthorized interference of the defendant with the possession and the enjoyment of his land. Direct interference may be there. Such interference with plaintiff's land must always be direct. For example, planting a tree on the plaintiff's land is a direct interference and it amounts to trespassed land. Proof of damage. When we talk about proof of damage, the tort of trespass to land is actionable per se, and hence the plaintiff need not to prove that they suffered damage, any sort of damage by such interference. Now, moving towards nature and character of tort of trespass. The nature and character of trespass can be studied under three main heads. Number one is trespass ab initio, trespass by abuse of license. Number third, trespass by continuing trespass. When we talk about trespass ab initio, the doctrine of trespass ab initio means that trespass from the very beginning, where a person enters upon the land of another under the authority of law and is subsequently guilty of abuse of his authority by an act of misfeasance. His misconduct relates back so as to make his original entry tortious, and he is liable for damages not only for the entry itself but all the subsequent act which he committed after the entry. In one of the cases titled Ilyas versus Basmori, the defendant, some police officials lawfully entered the plaintiff's premises in order to arrest the plaintiff. Subsequently, the defendant seized some documents related to the trial of person who was arrested. In an action by plaintiff, the defendants were held responsible as trespassers ab initio as to the documents seized and returned, but not as to the land. To constitute trespass ab initio, the entry of the defendant must be made by authority given to him by law or statute, but not by an individual. The defendants must have committed an act of misfeasance and not an act of nonfeasance. Leading case on this point is, which is popularly known as Six Carpenters case. Six carpenters consumed wine and bread in plaintiff's inn and refused to pay the bill. In an action for plaintiff, the owner of the inn, for trespass ab initio, it was held that the defendants were not trespassers ab initio on the ground that they had not entered the inn under an authority of law. They had not committed an act of misfeasance but an act of nonfeasance, that is, non-payment of the bill. In yet another case, it was observed that whereas police officer, while conducting search lawfully, assaults someone on the premises, his entry does not become unlawful thereby. In order that entry of a person to certain premises is treated as trespass ab initio, mere nonfeasance, that is, omission to do something, is not enough. It is necessary that the defendants must have been guilty of positive acts of misfeasance, that is, doing a wrongful act. It is also to be noted that it is not every act of misfeasance which can convert lawful entry of a person into trespass ab initio. It is further necessary that the act of misfeasance must be such that will render the presence of defendant on the premises as wholly unjustified. This doctrine of trespass ab initio has very little application in modern times. Now, trespass can also be committed by abuse of license. License makes an unlawful act lawful. It's an instrument which authorizes the defendant to enter the plaintiff's premises, whether paid for it or not. The person who issues license is called as licensee. The person to whom it is issued is called as licensee. If the licensee remains in the licensor's premises, abusing, misusing the license, it amounts to trespass by abuse of license. For instance, suppose A permits B to remain on A's land for a specific period of time. This B now continues to remain on A's land beyond that period. It amounts to trespass by abuse of license. Now, trespass may also be categorized under continuing trespass. Possession is acquired by trespass, gives rise to fresh cause of action for trespass if a person leaves an object on another's land. The right to sue him will continue unless and until the thing is removed. In the case of Hudson versus Nicholson, the defendants had wrongfully placed certain timber on adjoining land to support their house. This land was subsequently purchased by plaintiff. In an action by plaintiff, the defendants were held liable for trespass. In yet another case, the defendants, while demolishing his building, left some rubbish on the roof of adjoining building of others and subsequently became a tenant in adjoining building. As a result of that rubbish, the roof became choked and the building was flooded. The defendants were held liable to the plaintiff, the owner of adjoining building, although he had become tenant after the building operations had finished. In yet another case, highway authorities had made unjustifiable interference with the land of the plaintiff by wrongfully building buttresses on the land of the plaintiff. In an action for trespass by the plaintiff, they had to pay compensation. They were again held liable for continuing trespass for not having removed buttresses after notice. But if something is there lawfully on the land of another, to begin with, mere omission to remove such thing will not amount to trespass. The same will be the case where a man merely omits to restore the land in the same condition in which it was found. Dear students, this tort of trespass has certain defenses available. And number one defense for tort of trespass is leave and license. A license makes an unlawful act lawful. If the defendant enters another's land with a license, he is not a subject to the suit of trespass. A consent to enter on the land is known as license. A license is an agreement that it shall be lawful for licensee to enter upon the land of the licensor. For instance, for cutting timber or for hunting animals, a license only makes an act lawful which would, without such license, without such permission, be unlawful. It is a voluntary suspension of licensor's right to treat certain acts as wrongful. For example, to hunt on his land or to come into the house. License may be either express, as in the case of a guest in the house, or a person who purchased a ticket to go for cinema to watch a movie. Or the license may be implied one, as in the case of a customer entering a shop of a person habitually allowed to use the plaintiff's land as a shortcut. In one of the cases, the plaintiffs had purchased a ticket for cinema, but was turned out of the cinema house forcibly under a mistaken impression that he had not brought a ticket. It was held that substantial damage ought to be awarded to the plaintiff. Therefore, where a person is granted leave or license by the plaintiff to enter the land, he cannot sue him for trespass. Another defense available again is the tort of trespass is prescription. If a person continues an activity on the land of another for a period of more than 20 years, he acquires a legal right by prescription and is not subject to liability for nuisance. Prescription, that is the long and continuous use legalizes an act which would constitute otherwise nuisance or trespass. The period of 20 years is to be counted from the date when the plaintiff comes to know the existence of nuisance. In yet another case, the defendant had been using certain heavy machinery for his business. The plaintiff felt inconvenience due to the noise of the machinery and sued the defendant for the nuisance. The defendants were held liable on the ground that the period of prescription would be computed from the date when the plaintiff comes to know the existence of the nuisance. Another defense is lawful authority of the state. A suit for nuisance is not maintainable if the defendant's act is authorized by law or by statute. In one of the cases titled Dyer v. Mansfield, the defendant was a licensed vendor of fruits and vegetables. During the scarcity of potatoes, he was issuing only half of the quantity of potatoes per ration book. Queues of customers extended on the highway in front of neighboring shops. In an action by the plaintiff, neighboring shopkeepers, it was held not actionable. There is another defense, that is act of necessity. Entry on another's land may be justified. How? On the ground of necessity. For example, A may enter the property of B without B's consent to put out the fire and to prevent the fire from spreading. In such a case, A would not be held responsible as trespasser. Similarly, a traveller on a highway who finds it obstructed from a sudden and temporary cause may pass upon the adjoining land without becoming a trespasser. Abating nuisance, that is the removal of nuisance by the party injured, must be peacefully, without danger to the life and limb of others, and after notice to remove the same if it is necessary to enter another's land. A person may not be held responsible as trespasser in order to abate the nuisance if that nuisance is causing sufferings to others. And the defense which is available to the tort of trespass is self-defense. Trespass may be done in self-defense or in defense of man's goods, chattels, animals. Force used in self-defense must be reasonable, that is, must be necessary for the purpose and proportionate to the evil to be prevented. If a person has actual possession of goods and another wrongfully attempts to take the same from him, he is justified in using such force as is necessary for the purpose of his defending his own possession. Under these circumstances, self-defense is valid plea in an action for trespass. Another defense is re-entry on the land. A person who is wrongfully dispossessed of the land may retake possession of it if he can do so peacefully and without the use of force. He will not be liable in an action for trespass to land even if he enters in that land forcefully. With this, we conclude today's lecture on tort of trespass to land. I hope you understood it well. Thank you very much.